If you have not had any personal experience with a lawsuit, you may be surprised by some of the material presented in this video. Whether a trial takes place in a federal or state court, whether it's a civil matter or a criminal, there are very specific steps that have to be taken, as well as rules and timelines that have to be followed. All of this is called procedural law. While I hope to never personally be involved in a lawsuit, I feel that it's important to be aware of the process and be armed with as much information as possible. So thank you for watching our video as we take you through the litigation process from start to finish.
Afternoon. Today we will be wrapping up Zoe versus Peyton. I see the correct procedures were followed for the pleadings that include statements made by the plaintiff and the defendant in the lawsuit that detail the facts, charges, and defenses of the case. The plaintiff, Zoe, filed a complaint that 1. Stated the facts necessary for this court to take jurisdiction, 2. A brief summary of the facts necessary to show that the plaintiff is entitled to a remedy, 3. A statement of the remedy that the plaintiff is seeking. I see the defendant Peyton was served with a summons to file an answer to the complaint with this court and the plaintiff's attorney. The answer was received within the specified time period, so no default judgment is necessary. The defendant's answers to the complaint denied the charges and filed a counterclaim against the plaintiff. The plaintiff replied with a response to the defendant's answer. After reviewing all of the documentation, I grant a motion to dismiss on the grounds that the plaintiff, Zoe, failed to state a claim for which this court could grant relief. This court is adjourned.
A discovery, or motion of discovery, is a way for opposing parties to obtain information from each other prior to the case. It can come in 2 forms: in the form of a deposition, which is a sworn testimony under oath in oral form, or in the form of an interrogatory, which are written questions and answers answered sworn under oath that are in written form, or sometimes both. Other information which has to be pertinent to the case must come in written form, as well as to examine pieces of evidence that each party may have.
So the 7th Amendment of the Constitution guarantees the right of a jury trial for only federal cases when the amount in dispute exceeds $20, and in most states and in federal courts, one of the members needs to request a jury in a civil case or else one is not granted for them. A trial can be held with or without a jury. If it is held with a jury must be selected before the trial starts, and this process of selection is called voir dire. And during voir dire, defendant and plaintiff attorneys ask the potential juror just a few questions to make sure that they're not biased or have any affiliation to the party or witness. A party may question the juror peremptorily, which means not swearing in a juror without giving a reason, or for cause, which gives a reason as to why they shouldn't be sworn in.
Post-trial motions are made after a verdict has been rendered. A motion for judgment, NOV, meaning notwithstanding the verdict, is a motion that asks the judge to set aside the jury's verdict and rule in favor of the other party. This will only be granted if the jury's verdict is unreasonable or erroneous. A different motion can be made for a new trial. This might be granted if the judge feels that the jury made an error but does not feel justified in granting a judgment to the other party. A new trial may also be granted if additional evidence has been discovered or if there was misconduct by anyone during the trial.